Thank you for joining us today for webinar number 5, How to Be a Better Broker Owner and How to Help Your Broker Owner. I'm Laura Prowse from Crest Insurance Services. Today, we welcome attorney Mark Carlson from the Carlson Law Group. Mark has been defending real estate professionals since 1993 and has worked with Crest for over 20 years as a founding member of our legal panel. Along with Mark, we have Dave Miller, Regional Vice President with Fidelity National Home Warranty. Dave manages the Crest Advantage Home Warranty Plan, which ties into Crest's E&O insurance. We have a lot to cover, so let's get started.
Morning, everyone. Morning, Mark. Morning, Laura. Thank you guys for joining us today. The first 4 webinars that we put out have been very successful, so we know that they are being viewed, and we look forward to getting more information out to you guys today as we focus a little bit more on the brokers and the real estate brokers that are out there, and what are some things that they could do to ensure that they are running their business properly and managing their agents properly, and maybe some lawsuits that come up when they maybe aren't as active as they should be. So let's get started. Mark, what's the overall premise and responsibility of a broker who has real estate agents working under their license?
Well, it really comes out of the Department of Real Estate's the regulations. I'm sorry. So the regulations, sort of simply say that a real estate broker has the obligation to set up systems and policies in which to oversee not only the acts of the agent, but also of their agents, but also of their the information that is supposed to get to the principals within the transaction. And so I've been to many presentations by DRE top brass where they talk about there being the broker is being the Uber broker. There may be other broker associates, there may be other managers that are assisting, but there's one broker that is responsible for everything that goes on in the office, from agents' websites to advertising. So the broker really needs to, the Uber broker, as they would say, really needs to keep on top of everything that a realist or that one of their either salespersons or broker associates is doing. So that goes into providing training so that people are doing things the right way. A lot of times there's local requirements within a community or within a county that the broker needs to keep on top of, and then of course making sure that all the documents in a transaction are actually getting to the principals.
Got it. Perfect. So what exactly, and why should a broker care what the agents are selling? Can you go into that a little bit?
Sure. So there's I'll start with sort of the most, I guess, commonsensical, right? So if you've got an agent who has never done a probate sale and then gets a referral and wants to be helpful and take that probate sale, well, the license allows agents to do a probate type of transaction, but they may have no idea what they're doing. And so in that particular case, the broker would obviously want to either assist that agent or put somebody else to help out, mentor, to make sure that things get done properly. And that would go with, I'm doing my first commercial deal, or I'm doing my first raw land deal. I mean, everybody has their first. And so it's important for brokers and managers to know when their agents are doing something that's outside their wheelhouse, so to speak. Another thing that people often don't think about is that when an office is purchasing errors and omissions insurance, that's either the owner or that's an admin person, and so they know what the policy covers and what it doesn't cover. But sometimes that isn't communicated to the agents, and so if there's an exclusion for property management, which is getting more and more common, where a broker, if they want property management coverage, is going to be X dollars, but if they do without it, then it'll be X less some dollars. So the broker, to save some money, since the company doesn't do property management, will elect to take an exclusion for property management activities. But then the agent has somebody that says, "Hey, I bought this investment property. I'd really like for you to run my to run my rental," and they do it not knowing that the brokerage doesn't have property management coverage. So it's important for, and that could apply to, exclusions for mortgage brokering. Wouldn't necessarily apply to escrow, but just the point is you got to make sure that the agents know whatever what you're negotiating, what the broker is negotiating for in their exclusions. And so and that becomes a real problem when you get a lawsuit for an incidental property management and there's no coverage. Now the agent thinks, well, I should have had coverage because they paid maybe for their share of the E&O, and then there's no coverage.
Oh, that makes sense. That makes sense. So we know that there are still, even in this crazy market where it seems like there's a lot of agents and not enough to sell, but we still have a few thousand real estate licensees coming into the marketplace each month, which is just crazy. Why is new agent training so important for a real estate broker?
Well, so there's two things I would say most brokers would say is every company wants to create their own culture, and that is what they assume is what attracted the agent to that company in the first place versus going somewhere else. So it's important to be able to develop the culture of how things are done within a company. And then another is just sort of the nuts and bolts of the practice of real estate. Getting being alert that when new forms are released. A lot of times new agents won't think to go look. All of a sudden there'll be on their win forms, it'll pop up, or they won't even look to see what's been added. And now they're using now it's hard to use an outdated form, but because they upgrade, but they're not using forms that they should be using, especially with this COVID. And obviously we've gone over that on a prior session where CAR was releasing new PEDs or PEDS forms, seemingly every quarter. And so it's when you don't use the proper form, or don't use a mandated form like the new home hardness disclosure that's now a mandatory form, then you're not complying with the standard of care just because an agent isn't familiar with what forms to use. And then a lot of times brokers will go to meetings at a local association, or go to the CAR meetings and become aware of new issues. And agents, especially when they're new, they're not thinking about that type of real estate activity. They're just pounding the pavement trying to get listings or trying to get buyers. So it's helpful to pass on new industry information to agents also, so that they can be compliant, and then also just sort of be more professional.
Perfect. Well, I tell you, let's switch gears a little bit over to E&O insurance, obviously errors and omissions insurance. And we hear and we know it's illegal for a carrier to insure fraud, or to have coverage for fraud. There's still a lot of confusion in the marketplace on what exactly fraud is, if it's unintentional misrepresentation, or is it purposeful fraud. Can you kind of get into that a little bit with us and give us kind of a dumbed down 101 on exactly what it is?
Well, first, Dave, I would start by saying that I'm not so sure that your statement that people know they can't insure for fraud because it's illegal. I think that's something that a lot of licensees don't appreciate. And so let me touch a bit on that to make it clear. So the insurance code actually has a provision that says an insurance company cannot insure somebody for their own intentional acts. So and that goes across all policies of insurance. So if I'm driving in my car and I see my arch nemesis walking on the sidewalk, and I purposefully take my car and run into them to get them off the planet, that would be an intentional act that wouldn't be covered under my auto policy. If on the real estate side, it's harder, I think, to conceptualize what fraud means. And so to get sort of into the thick of it all from a legal perspective, an intentional fraud claim is a positive assertion of fact, meaning you have to say something affirmative about a property that is not true, that the person giving the information knows to be not true, and they make that statement with the intent to induce reliance. In other words, to get somebody to do something, and then the reliance results in damage to that person. So that type of finding, that's intentional fraud, and that would not be covered because under any policy, because it wouldn't, it's not allowable under the insurance code. But then there are other types of representations that are more difficult sort of to define. So first would be a negligent misrepresentation. And a negligent misrepresentation is sort of the same elements, except for that the person, the second element about that I know it's not true, it's that element is changed to that I don't have a reasonable basis for believing it to be true. And the way that this comes up is I got an example I use over and over again. If I'm an agent and I'm in the kitchen on a showing, and the buyer says, "Hey, is the fence on the property line?" And I look outside the window and it looks like it is, and I say, "Yes." Well, now I've just made a positive assertion of fact, and if that turns out not to be true, then I'm left with the jury just trying to determine, okay, did I know that it wasn't true? In other words, did I see a prelim, and did I realize before I said that the fence line was actually much closer to the house, so that the house really didn't have the big side yard that it appeared to have, in which case that's fraud and I don't have coverage? Or am I just lazy and I didn't look at the prelim and I just assumed it was with no basis for assuming? And of course, the plaintiff is going to try to prove that it was made intentionally, and then the agent is going to try to hope that the jury believes that they just made an innocent mistake by saying something that they shouldn't have.
Well, I appreciate that. Well, we all know that real estate E&O claims can be very time consuming and frustrating for all parties involved, especially when you are dealing with a really a busy broker or agent, because it puts a stop to a lot of their work. How does with all the different means of communication now, text and email and so much other stuff, how does a broker and agent really know if they have a claim?
Well, most policies define a claim as a demand for money that arose out of the provision or providing of real estate services, and so that's where it's also important for agents to communicate directly with managers or their broker when they have a complaint from a client. It could, like we've had circumstance where there's a demand for money, but it's really just made to the seller, or that the letter appears to be made out to the seller, but the agent is copied on the letter, or maybe the letter is addressed to both the seller and the agent, and the buyer is only including the agent because they don't know how to get a hold of the seller directly. Well, if that's demand is reasonably likely to result in a claim against the broker, then that letter, although not directly demanding money from the agent, might be determined by the carrier to be a demand for money and constitute a claim. And so if there's anything that complaints of any sort really needs to be communicated to a manager or the broker for another reason, which is, when an agent is doing their level best on trying to handle a transaction and somebody calls them a dirty rat, that they didn't do what they should have done, there's an emotional component to that, right? You tried to be as helpful as you could in the transaction, and now somebody is criticizing you. And so sometimes that emotional element clouds an agent's judgment. So when an agent gets a broker or manager involved, it eliminates that the manager and broker presumably won't have the same emotional investment. So and another reason too, going back to my comment about the insurance is purchased by the manager or an administrative person. If an agent gets a letter, a threatening letter, or even a demand letter, and then just doesn't do anything with it, And then and this happens quite frequently. The buyer says, well, maybe I just, I'm not going to do anything about it. And then the next rain comes, or the problem manifests itself again, or they realize that the problem is bigger than they expected. And now they file a lawsuit. Well, if the policy was rewritten between, in other words, if there was a renewal that occurred between the time of the demand letter and the complaint, the insurance company could deny coverage by having prior knowledge of a claim. And so, because when an insurance company underwrites, they're underwriting based on what they think the current risk is, and if there's a pending or a brewing problem, they may underwrite and charge premiums, different premiums, if they knew about it versus if they didn't know about it. And so the agents need to really be communicative and give those threatening letters to the brokers so that they can, hopefully, every broker that's watching this has a file in their office next to their insurance renewals that they put every threatening letter that they get throughout the year. So then that way, okay, this went away, or this is still potentially active, or even just disclosing it, saying, hey, here's the 5 lead, or however many, hopefully it's none, threatening letters throughout the year. And then, you're not going to have a coverage problem based on a prior notice issue.
Okay, so now we have a claim. It's pretty clear. What does a broker do next? How does he hand it to the carrier, and what are some steps that they should take to support their documentation?
Yeah, so the whole file then needs to obviously be preserved. So the agent needs to print out whatever text messages that they had, and they need to get their emails printed out. So everything all the proof of communications during the course of the transaction, then of course all the transaction documents, which should already be in the file, but everything needs to get bundled up together. And so that way, because at some point the insurance company the adjuster who is assigned to the claim is going to ask for that file. And then when it gets to an attorney like me, of course, we're going to need that file. So it's very important to sort of, I call it circling the wagons. Let's look at everywhere and make sure we got everything. And if there are phone calls that were made that potentially are important, grab that telephone bill now, when it's still relatively fresh before it gets destroyed. So that every bit of information that might be needed is in one place.
Perfect. So how about the E&O premiums? Of course, now we know we have a claim, and they probably settled on a claim for our office. How do claims really affect the cost of E&O insurance for a broker for years to come?
So the insurance premiums are based on what that particular insured cost the insurance company the year prior. Same way with your homeowners. If I've got no claims, I'm going to get one pricing. If I've got a bunch of break-ins, and the insurance company has had to pay for things, I'm going to get a different price. Or car insurance. If I have a bunch of car accidents, my insurance rates are going to go up. So the focus really is to keep the total cost of a claim down, because that will be more friendly for your premium. So whether it gets paid to defense costs, paying me to defend the case, or whether it gets paid in settlement, so they call it indemnity, the insurance company doesn't care. They're looking at both, what the total is of both buckets. And so I've got 2 examples of this. You've got 2 brokers that are on opposite sides of the street from one another. One has 5 lawsuits in a year, and each of those lawsuits, the broker or the insurance company and the broker agree, let's just pay $5,000 and get out of each of these. And so there's a frequency of there were 5 things that they did wrong, or arguably did wrong, and during the course of that year, versus the other guy or gal on the other side of the street, they've got 1 claim. And that broker dug his or her heels in and said, we didn't do anything wrong. I'm not paying any money whatsoever. And they take that case all the way to trial, and they get a defense verdict at trial, and it cost them $100,000. Well, the broker with 5 claims, interestingly enough, is likely going to get a lower premium quote the next year than will the broker that had 1 claim that they defend. And so it really becomes an issue of, and it's, we as Carlson Law Group, are focused on trying to get the best result from the client. And sometimes the best result is the one that doesn't taste very good. And so I've got this, what I call the continuum of pain. So sort of similar to my two brokers across the street from one another. Another way to look at it is if a lawsuit came in and you were able to predict the future and knew that it was going to cost you $50,000 to get rid of the case, I'm sorry, to defend a case all the way through trial. If the plaintiff says, you know what, I'll go away for $5,000. Well, even though you didn't do anything wrong, that $5,000 is a better business decision than fighting all the way and spending $50,000. It feels horrible, but that's an easy business decision, right? So where it gets tricky is, okay, now it's not 5, it's 25, or it's not 25, it's 35. And where along that continuum is it that you just get too close to where it's just going to be a problem for you in any event, and you have to go all the way through trial, or where is it that you say, okay, enough's enough, let's just get rid of this claim and try to make a good business decision.
So do brokers have a say in, no, we're going to fight this, or does a carrier kind of override that based on the information from the claims adjuster and the attorney?
It depends on the policy. So
Okay.
There's what they call a consent clause. So some policies are written to where the broker has the ability to the last say, the veto power, so to speak, over a settlement. And then there are other policies where the broker doesn't have the ability to consent.
Perfect.
But so I just have to say on that regard, just again,
Yeah.
my experience for doing this for a really long time, I can count maybe on two hands where over all that time where the insurance company wanted one thing and the broker wanted another thing. I think when you get right down into it, everybody wants the same result, which is to have the claim to be as cheap as possible. And so sometimes, it's like, well, I really don't like this. There's a dispute over what the best road is to the lowest cost. But I don't know that I've ever actually seen a case that I've handled. Well, I shouldn't say I don't know. I have not had a case that I've handled where at the end of the day, there was the broker and the insurance company were on polar opposite sides of the decision to settle, and the broker nixed the settlement deal and then had to go forward and deal with the consequences with that. So it just, I think most people realize it's a business decision that they have to make together.
Sure, and we know that E&O rates have been a little bit higher in the past few years, and a lot of the real estate brokers have increased their deductibles so that their costs are a little bit more cost-worthy for the agents in the office. Can you explain real quick while we're here, if an office does have, let's say, a $25,000 or $2,500 deductible or a $5,000 deductible, and they are getting rid of these issues before they even turn them into the carrier, what are some of the things and measures that a broker should do so that it doesn't blow up down the road if they go ahead and make it go away under the deductible and not turn it in?
Well, so if you don't turn it in and you renew, then we come with the prior notice issue. If you don't turn it in, you defend it, and then something happens, there is a notice and cooperation clause, and it's so fact specific that it really would be hard for me to give any usable information on that. But the concept is that if an insured does something that jeopardizes the insurance company's ability to defend the case, then there can be a problem with coverage. And so if a broker is going to not tender something, they probably, and just handle it on their own, they probably need to have a heart-to-heart conversation with the attorney that they're having help them, or get an attorney involved to evaluate that particular issue based on the facts given in that particular case.
So the forms where it's I paid you the $300 for this issue, is there any kind of form that they could have the other party sign that they're not bringing this up again, like a release?
Yeah. So if a company wants to resolve a claim, within the deductible, they for sure want to get a release for that, so that they don't pay money and then they come back, once they realize, hey, that was an easy target. Let me make up something else, and then now all of a sudden, you're having multiple claims from the same buyer. And I would say the same thing that holds true if there's a dispute during escrow, and then the agent say, okay, well, I'll contribute a portion of my commission to fix that particular issue. You want to get a release in exchange for that concession on your commission also.
Perfect. Is that a CAR form, or is that something that somebody puts on their letterhead and has both parties sign?
Well, the CAR doesn't have a release form, so you would want to have, you know, your attorney prepare that for you. You know, that's something that we do under the CREST risk management program. When we get those calls, we do that frequently for callers. So anybody who's watching this must be a CREST member. So they have that benefit also. So if you're in a deal, that would be a good, and they are going to give a commission concession, or if you resolve something outside of your without tendering a claim, I for sure would make a call to the risk management line, and you can have one of our attorneys or the other couple of firms that do it to help them out.
Fantastic. Great information today, Mark, on just not only brokers and how they can manage their agents better, but even for the agents that are watching this, what are some questions that the agents can ask their brokers? And I think you addressed a lot of those, in particular about the E&O coverage and what their activity is covered and what isn't. And then, of course, with E&O, there's always a lot of misconceptions. So you cleared a lot of those up for us today. We appreciate that. For everybody, we look forward to the next webinar. And thanks so much for watching this one. Laura, back to you.
Thank you, Mark. Thank you, Dave. Always very, very informative. And for all of you, thank you for watching. A copy of this webinar is available on the Crest Insurance homepage if you look under the Claim Prevent blog. We look forward to seeing you next time. Bye-bye.